Stand, please. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-1071. Secretary of Labor, Mine Safety, and Health Administration, petitioner, versus Casey Transport, Inc., and Federal Mine Safety and Health Review Commission. Ms. Maltz for the petitioner, Mr. McHugh for the respondents.
Good morning. Ms. Maltz, we'll hear from you. You have me confused because you're sitting where the respondents usually sit.
Oh, I apologize.
That's what you normally are.
Yes,
So,
yes.
at any rate, good morning.
Good morning. May it please the court. I'm Susanna Maltz, petitioner secretary. I'd like to reserve 2 minutes.
Can you please move the microphone a little closer? Thank you.
How's that?
That's great.
Very good. This case is simple. The Mine Act gives MSHA enforcement authority over mines. Section 3H1C of the Act defines mines as including equipment and facilities used in mining. The subsection is clear that equipment and facilities used in mining are mines due to their function, their use, and it does not require them to be located anywhere in particular to be considered mines under the Act. A reading of this court's decisions in Donovan versus Carolina Stay-Lite and Secretary of Labor versus National Cement Company of California conveys this as well. In Carolina Stay-Lite, this court determined that the Act does not require subsection C facilities to be located on property where extracted. And in National Cement, this court determined that subsection C reaches vehicles used in mining, but not on subsection A.
But how do we deal with the fact that, in I think it's section 103, or how do we deal with the fact that inspections are required to occur, I guess, twice a year, according to 813A of each surface coal or other mine in its entirety?
MSHA is required to inspect surface coal mines 2 times a year, and to the extent that these equipment and facilities, et cetera, are considered mines under the Act, MSHA will inspect them. That's MSHA's role. Casey Transport has suggested that this will explode. This burden will weigh on the agency, but it's not a burden for MSHA to enforce the Mine Act.
What I guess I'm getting at is, in order to inspect something, you have to know where to find it, and especially if it's a mandatory requirement that an inspection occur, a certain number of times per year. And so it seems that in that sense, it would kind of be congruent with Congress's intent that there be some sort of location aspect to Part C of 803.
I disagree that Congress.
I'm sorry, 802H3.
Congress didn't require a locational element, although I do understand the congressional requirement that mines be inspected. These circumstances play out the way that they did. An inspector was present at an extraction site, traveled to Casey Transport's maintenance facility, and observed violations of the Mine Act standards. This is how subsection C applies. This is how MSHA inspectors would and will and do enforce the Mine Act where equipment and facilities aren't located on the extraction site.
I guess what I'm saying is that I don't know that you necessarily lose because there's a location aspect to this part, subsection C, but um, it's in poker. I'm just going to tell you what I'm thinking right now. You tell me your reaction to it. So it appears from our decisions in, I think, Donovan and National Cement, that one way that you could look at this is that in H1, A has been interpreted mean the land and everything that's on the land. B, the private ways and roads pertinent to such area. We expressed some concern that if that meant private roadways and roads appurtenant and everything on that area, that could be too broad because roads could be used for non-mining activities. And so as a result, we sent it back. The secretary said, well, the road itself, as long as it's kind of principally used for mining activity, can fall within the definition of a mine. And to the extent that there is equipment on the road that's used for mining activity, like a truck, then that is also a mine. The commission seemed to say that geographically, a mine can't go beyond either of those two places defined in A or B, in that C cannot geographically expand the jurisdiction of the Mine Act. Mines can't be beyond any place that would fit within A and B. To me, that seems wrong because it goes against, basically C wouldn't do much work at all if that were correct. But that doesn't mean that any truck found anywhere that is coming from a mine or on its way to a mine is a mine. The equipment, machines, tools, or other property that's being referred to in C has to be located on or a part of the rest of the things that are in that subsection C: lands, excavations, underground passageways, retention dams, tailing ponds, etc. What's wrong with that interpretation?
Let me see whether this answers the question. I agree that the commission's decision is wrong. Subsection C items need not be located on subsection A mine or subsection B road in order for MSHA jurisdiction or in order for the mine act to reach. So whether or not a truck is coming or going from a mine wouldn't necessarily, the act wouldn't necessarily cover that truck. The analysis is whether or not that truck is used in mine. That seems rather broad, but that is what the statute says. May have not answered the entire question.
Well, I guess all I'm saying is that this is a somewhat oddly written statute, and one thing I haven't been able to chase down yet is that I noticed that the legislative history says that this language from subsection C may have been taken from the Federal Metal and Non-Metallic Mine Safety Act, because Senate report says that the definition of mine was enlarged to include the mines that were previously covered by that act. And so it appears to me that language from subsection C may have come at least in whole or part from that prior statute. Do you know anything about that?
Yes, the Mine Act, the Coal Act originally applied only to coal mines. The Mine Act expanded the coverage of that statute to reach coal mines and other mines. So the language in subsection C, there's I don't want to say analogous. There's some language that is similar to subsection C in the Coal Act, and there's some language that's similar to subsection C in other acts that previously regulated other mines in the industry. To the extent that your question is sort of getting at, did Congress intentionally leave a locational element out of subsection C? Yes. Did Congress, give MSHA jurisdiction over all these items, including items that were relevant in these other statutes? Did Congress give MSHA jurisdiction over those and not require them to be located on lands in A or roads in B? Yes. Is that what you're getting at, Judge Wilkins?
Can I ask, I think this might go to Judge Wilkins's question. I think we said in National Cement 2 that subsection C reaches vehicles used in mining, but not located within an extraction area. And I think the question is, are there any limits to this? The hypothetical of a mining truck parked in a diner parking lot, things of that nature. Is it your position that subsection C would apply to such a truck parked in a diner parking lot, or a tool in a miner's house?
The answer is no. Well, the answer is it depends. The subsection C reaches. I apologize. I see I'm over time. I'll just quickly answer.
You can continue.
Thank you. The act. So whether or not something is used in mining is a fact. If something were, after an analysis of the facts, determined to be used in mining, MSHA, the statute does apply to that. There is a limiting principle in the statute, and it's the use in mining test. There's not a locational, the statute doesn't require any particular location, but trucks in diner parking lots, MSHA would not stray outside the bounds of reasonable enforcement. And
is there a temporal limit on that? Like, is there a temporal limit on that? What if it was used in mining 30 years ago?
I'm sorry. Yes, I think that type of fact would go into the analysis as to whether or not it's used in mining, and it would be considered amongst those other facts. If something doesn't remain used in mining for years, if that's what the question is getting at, there's not a permanence to use in mining.
So your position would be that the truck used to transport coal that's parked in a diner parking lot could be inspected in the diner parking lot?
MSHA would not inspect a truck in a diner parking lot.
But it could be.
But the statute, if the truck is used in mining, the statute would cover.
On Judge Pan's question about a time limit, the statute says, quote, to be used, extracting, milling, etc. So if the truck had not been used for 30 years and was going, quote, to be used in 5 years, truck a mine?
I think that I would need additional facts, but
it could be a mine.
If the truck is to be used in, based on the universe of facts about the truck, then yes, the statute. But
broad reading.
Only knowing. I'm sorry.
The broad reading of the statute.
Yes, and Congress intended the reading to be broad. Congress, in fact, intended the reading to be as broad as possible.
So I think I know the answer to this hypothetical based on your answer. It's a hypothetical I've had in mind. It's probably more realistic than the truck. My hypothetical I just gave you. The truck that's going to be used. So I drive a truck. The truck has no commercial purpose other than be used for mining. And I drove it on Monday at the mine, and it's the holiday season, so drive it across the country to visit my family in California. Drive it from, where was this mine? This case.
I'm sorry, Southern West Virginia, I think?
West Virginia. Drive it from West Virginia to California. That takes, a few days, a week, whatever. I'm going to drive it back. It'll take me about a week to drive it back. While I'm in California and it's parked at my mother-in-law's driveway, is this truck mine?
Judge Walker, I don't mean to disappoint you, but it's very factually intensive. I don't mean to, I understand the court's interest in testing the boundaries of this using hypotheticals, but if the truck, after a robust factual analysis, is found to be is determined to be used in mining, then the statute would.
I think that's more of an answer than you told me you were going to give me, because I think your answer is it could be a mine.
Yes, but if you would like to challenge MSHA's exercise of jurisdiction over it, the courts, you could raise that challenge for these outlier fringe hypotheticals.
And so just if the truck has been used and will be used, you have no geographic limit.
Yes.
And then one last, I guess it's not really even hypothetical, but presumably there was a mechanic who was working on the trucks in this case, either at the time of inspection or shortly before. Section G defines a miner as miner means any individual working in a coal or other mine. And of course, then Section H defines coal or other mine. So in this case, the mechanic who worked on these trucks, was that mechanic a miner?
Yes. Yes, and that analysis would also, have to do with whether or not that person, worked for KC Transport. There might be other facts that sort of shed more light on that. But yes, under these, yeah. I'm happy to.
I guess what I was trying to get at, probably not very artfully, I'm talking about the Congress creating a mandatory inspection regime. It's not like secretary may inspect, but it's the secretary must inspect in a particular, with a particular frequency. It seems to me that then, since coal or other mine is the definition that is pertinent to that inspection requirement, that coal or other mine has got to be construed to mean some sort of a land or a road or some sort of like stationary physical facility that is involved in extraction and related things, and then any other equipment that is on that land or at that facility that is used in conjunction with those kind of mining activities, those extraction type of activities. And so that way you give some meaning to Part C, and Part C means locations can be beyond what is in A and B, but it's still got to be some sort of a facility, a building, that sort of thing, and then the equipment that that services the activities that occur there. What's wrong with that interpretation?
I think I understand. There are these static items in subsection C, and it would be much easier for MSHA to inspect, a facility or a tailing pond that sort of lives in one place. And there's, if these trucks are mobile and they travel, then that poses a challenge. But the statute says equipment used in mining. And insofar as those trucks alone are equipment used in mining, MSHA would inspect them, though they travel.
So, okay. I mean, I don't want to belabor this. It can't be the case that, a traditional mining company could evade inspection of its trucks by, like, secreting them away, at some place, a few miles away from the mine, in a parking lot, and say, well, there's no extraction or anything happening there. So that physical area is not a mine, and these trucks can't be considered mines, and you can't inspect our trucks. That would be kind of an absurd result for a mining company to be able to do that. But I think that that seems to be distinct from saying that a truck it would seem to I guess I'm just trying to understand, help me understand how the secretary implements the mandatory inspection responsibility under your construction of the statute.
I think that the typical scenario is sort of one like this case. These trucks traveled between the extraction sites and the preparation plant, and then they were located nearby. It would be sort of bad business practice to store your trucks extremely far away. That's typically how these scenarios play out. When a truck is used in mining, the Mine Act. The sort of like travel and geography might lend itself, that would be considered. But if the truck is used in mining, MSHA, I understand that your question is how will MSHA locate these trucks as they travel around, and I think typically MSHA will locate these trucks because they will be nearby, but nearby is not a requirement for the statute.
But more broadly, I think this raises the issue of there's a mandatory inspection provision in 30 USC 813A, and it says you have to inspect twice a year. And if you define mine to be equipment, how do you know what all the equipment is so that you must inspect it twice a year? I think that's the question.
Typically in the mining industry, this equipment, these trucks, et cetera, MSHA has a sense of where they are. They're used in mining, and so there is a relationship between that equipment and those facilities, et cetera, and the mine, particularly those static facilities. MSHA has a sense of where things are, but so in order to inspect, MSHA will find.
So is it your position that these trucks are equipment, they're mines, they would have been inspected? Typically, they might have been inspected when they had hauled the coal to the physical site, and you would have known they were there and inspected them there. But in this particular occasion, you happened to see them in a place that was not physically located at or pertinent to a mine, and you're still allowed to inspect them? Is that kind of where we end up in this particular case?
I think that's fair. If MSHA did cite these trucks when they were on the extraction area, so MSHA had jurisdiction to cite them under A. They also traveled that road, so MSHA would have had jurisdiction to cite them on that road. And in this instance, they remain equipment used in mining even as they travel away from that extraction area and that road. And so in this instance, an inspector discovered them being worked on without being blocked against motion. And so, the statute still reached them at that time.
So I just want to make sure I understand the facts correctly. The trucks that are the subject of these two citations had been cited previously at a different location than where they were located, where they were cited here. The subject of this petition.
Yes. They had been cited while at the extraction site.
So, I guess one argument in your favor is it would be odd for them trucks to be mines at one time, not mines at another.
Yes, and the hazards that are associated with those trucks don't disappear when they travel across an imaginary line.
You may not know the answer to this, but I guess as a practical matter, does MSHA have some sort of regulatory process whereby it requires, mining companies to kind of give it an inventory, so to speak, of all of their various facilities that might fall within the definition here?
I apologize that I don't know the answer to that. MSHA has many regulatory record-keeping infrastructures, but I'm not sure about the answer to that.
One last question. It wasn't clear to me. We talked about in the Donovan v. Staylight case that the interagency agreement between OSHA and MSHA.
Mm-hmm.
I didn't see, I think the ALJ decision may have referenced the interagency agreement. It doesn't seem to be any discussion of it in the commission's decision, or I think even the secretary's decision, and not in the briefing. Is it not relevant, or why is it?
No, it is relevant sort of to these, to whether or not MSHA will reasonably stay within the bounds of reasonable enforcement. The memorandum of understanding lays out sort of certain situations where MSHA or OSHA has jurisdiction over very specific things, and then it contains a provision that says that the agencies will work together and that they'll attempt to achieve convenience of administration, and that they will contact one another when it's relevant. And I think the convenience of administration piece is quite relevant to this case. It makes sense for MSHA to inspect equipment used in mining. MSHA is the agency that's tasked with regulating the mining industry. And in terms of this particular case, it made sense for MSHA to inspect these trucks in this facility because MSHA was there. I hope that addresses the relevance of the memorandum.
But is the current iteration of that memorandum of understanding in the record here?
No.
I didn't think I saw it.
No.
Where would I find it if I wanted?
I believe it's published in the federal.
The other?
I have one, I think just one. If we rule for you in this case, we would have to create circuit split with the Sixth Circuit on what your brief calls a simple question of statutory interpretation that has significant consequences nationwide. Is that right?
No, I would say no. The Sixth Circuit has already split with this court. The Maxim is out of step with National Cement and with Carolina State. Maxim requires a locational, Maxim requires that subsection C items be located on subsection A or B mines. And that's just not congruent with cases of this has already. So it's the Sixth Circuit that has already split from this.
So we would be reaffirming all that stuff I just said rather than creating. Is that right?
Thank you. I'm happy.
So you said that we have already said that C extends beyond physical locations that are in A and B. When did we do that?
Donovan versus Carolina Staylight addresses a facility that was not located on subsection A extraction area of land where minerals are extracted. In that case, this court said that the subsection C facility need not be located on that land. And then National Cement, this court recognized that subsection C was an independent basis for jurisdiction, and that vehicles, equipment need not be located on a subsection A area. And I recognize that in National Cement, these trucks were on a subsection B road, but this court did not hold that they were required to be on a subsection B road in order for subsection C to attach.
So okay, I hear your argument. I think that in Donovan, I guess we didn't say that particular facility was in a location that fell within subsection B, we did point out that the facility was basically directly adjacent to the extraction area. But I guess I take your point that that wouldn't make it within subsection B because B says private. We didn't rely on subsection B to find that to be a facility subsection C.
Yes, and I would also say that this court didn't rely on the fact it was adjacent, happened to be adjacent, but that, didn't bear on the application of subsection C to that facility.
Thank you. All right.
Thank you very much.
Please support James McHugh on behalf of AC Transport. Before I launch into my argument, I did want to clarify 2 points. One is that the trucks that were cited in this case were not the ones that had previously been cited by the inspector. He was going up to find 2 different trucks, and then he cited these trucks. I just wanted to clear that up. And then as far as the memorandum of understanding, it's my understanding that it came down as a result of like the last sentence in section 3H that talks about milling. And because milling facilities sometimes are crossed between a milling facility under 3H and an actual manufacturing facility, the Congress said, well, you need to get together and work this one out because it's right on the edge of a manufacturing and a milling facility.
Let me ask a fact question. It's probably not going to decide the outcome of the case, but I don't know a lot about coal mining. The statute talks about extraction, milling, and preparation. I get what extraction is. What's the difference between milling and preparation?
There's definitions for those different things. Preparation plant is how they get the coal ready to ship it out, Your Honor, and the cases talk about how the extent of the preparation plant. Preparation plants are regulated. In fact, this Elk Creek plant was a preparation plant, not an extraction plant, but it wasn't a milling plant. So there's some distinctions in the definitions on what a milling plant.
So the stipulated facts say that the cited trucks are inspected regularly by MSHA when they are at the 5 Ramaco Resources mines and at the Elk Creek prep plant along the Hall Road. So these trucks are inspected regularly. It just happened in this particular occasion to be in a parking lot.
Your Honor, yes, the trucks are inspected regularly. In the sense that when they're on the mine site, for example, when they're at the prep plant, when they're at the extraction sites, and when they're on the roads, they are inspected regularly.
So your position is that they're a mine when they're at the extraction site, but they're not a mine in the parking lot?
Yes, Your Honor. When they're at the extraction site, the milling site, or the extraction site, the preparation site, and on the road, we agree they can be inspected because at that point, the contractor becomes an operator when he's performing services at the mine. And these trucks can be inspected, Your Honor. So KC Transport's position is you have an independent maintenance facility, KC Transport. They have 5 of these. They're spread out. Some of them are in the middle of town that service trucks. This one happens to be where it is, which the facts talk about. Our KC Transport's point is if the Secretary's analysis of Section 3H is approved, then there really is no stopping point. And I think the court's already talked about some of the situations that could come up, like equipment manufacturers refurbishing, tire repair, for example, radio repair, sawmills that cut timbers to go in the mine. Because this is an equipment that is to be used in mine, a timber, while it's sitting at the sawmill, it would be subject to MSHA regulation under the Secretary's limitless approach. Warehouses with fork trucks would be subject to the Secretary's approach. And I'm sure that the court and the commission has talked about some of these other things. And that's why it's so important in KC Transport's position to look at the Section 3H1 as an overall whole regulation under Chevron. In other words, not to isolate subdivision C and say, well, subdivision C says equipment used or to be used or resulting from mining. That's an overly broad reading. You're taking one section out of context.
Just so that I'm clear about your argument, the legal structure of your argument, you are not contending that subsection C is unambiguous.
That's correct, Your Honor.
You concede that it's ambiguous.
Oh, no. I say I think it's unambiguous. I think
You think that it's unambiguous.
Yes, Your Honor.
So we should find that it's unambiguous, at least with respect to this application, or it's unambiguous in general.
I think it's unambiguous in general, Your Honor. And the reason I think that is because even this court in the Cal Portland case says that if you read it and you have some thoughts or some second guesses on first reading, you still have to consult all of the tools of statutory construction, such as text, structure, history, and purpose. And what Maxim did and what the commission did here is they looked at C and they said, okay, lands and equipment. But when we look at this, it's in relation to extraction areas, roads, preparation areas, milling areas. So in other words, you can't just look at C in isolation and say, okay, if an equipment's used in or to be used in or resulting from mining, that it's automatically a mine, because that's not the way Congress intended. Surely Congress did not intend to regulate the coal truck, for example, that drives to California and says that when this person who's driving it arrives at their parents' house for dinner, they've got to, chalk it. Now, should they do that? Yes.
How do you explain our decision then in Donovan v. Staley?
In Donovan v. Staley,
we relied on subsection C there, or the secretary did, and we upheld that as reasonable, right?
And subsection C in the Donovan versus Staley case, that's a preparation plan. In other words, the mining materials, the gravel or an aggregate, was going directly into this gravel processing facility. So that becomes a processing plant under subsection C. So our position is that when equipment is being used at an extraction site, a processing site, or on the road, it can be inspected. There's jurisdiction for that. And that goes to the question of what the court, you brought up, Your Honor, that how do you know what equipment's
But that's not what the Sixth Circuit said, and that's not what the commission said. The commission said that, and I'm looking at JA 164, commission said, after construing this statute, that that subsection C does not have a further geographical extension of jurisdiction beyond A and B. And I don't see how that's consistent with our decision in Donovan, and I don't see how that's the correct interpretation of the statute. And it's not what you're saying to me right now.
Well, what I'm basing mine on is the fact that their Elk Creek prep plant is part of the extraction operations, just as the Stay-Light case was. In that case, it was even more clear because the conveyors went right into this facility. So it was like right there. It was adjacent and pertinent to. So it falls under the commission's rule there. I don't think, the commission
didn't, the secretary didn't rely on B there. Mm-hmm. And this was upheld under C.
Yeah, I meant it was next to A.
Yeah. But it didn't fall within A, mm-hmm, technically, and it didn't fall within B, right? You would agree that it didn't fall within A or B and it fell within C in Donovan.
I think the Stay-Light, my recollection of it, and I'd have to look at it again, but as I understand it was a prep plant that was adjacent to the extraction facility, and the extraction facility dumped its gravel right into the prep. That's my thumbnail recollection. So our point is that the commission is correct that C is not just a read-alone thing without a locational reference, that the lands and the equipment must have a locational reference to the areas that are a mine.
Another thing that the commission said was that the Coal Act, the definition of coal mine in the Coal Act, this is at J161. They said they listed the definition of a mine from the Coal Act, and then they said, the Mine Act that came 8 years later was only intending to clarify the definition, and it wasn't intended to expand the definition. And I'm not sure how that can be right, because the Mine Act retained the definition of mine from the Coal Act, but they put it in H2. So that's in, 802H2. It said that it includes a definition for coal mine that applies to certain subchapters 2, 3, and 4. And when I look at the definition of coal mine and looked at the definition of mine from the Coal Act, it seems to be verbatim the same. Do you agree with that?
Your Honor, to start where you started with the commission saying that they were attempting to clarify the Coal Act. And I think in context, what their comment was, the clarification was, in addition to just the straight extraction area, you've got these other things that are listed in C, and these are intended to be those things that are around a mine otherwise. And I think that's the point that the commission was trying to make, and I think it's well founded. It's the same point that the Maxim Rebuild Court made. As far as the specific language of the Coal Act, I can't answer your question on that, Your Honor, because I haven't looked at that the way Your Honor did.
Do you think Donovan would have come out the same way as it did in our court if Donovan had applied the Sixth Circuit test? I think the Sixth Circuit test says it'll be covered by H1C if it's adjacent to an extraction site.
Yeah, I think Your Honor probably would have come out similar, because it's not only adjacent, it was integrated. It was an integrated extraction / preparation facility. So I think even the Sixth Circuit would probably agree on the Donovan versus Staylight case. I think the Sixth Circuit's situation deals more with these independent, non-mining related companies that are doing things other than mining, other than extraction, other than milling, and other than preparation. Those, sawmills, tire repair companies, radio repair companies, and independent facilities that repair trucks, whether it's Casey Transport's repair facility or the repair facility down at the corner where the coal truck leaves the mine site and goes there to get a tire replaced. I think that was the difference between those two. So I think our reading of the regulation or the statute is entirely consistent with what the court normally does under Chevron, which is they look at the statute, and then they look at the tools of regulatory construction to see how that section relates to everything above and below it, including not just in Section H, but also Section D that the commission looked at as far as when is a contractor enough, when they're at the mine performing services. Under the Secretary's reading, they'd be an operator all the time, even off the mine site. So there would be no need for Section D to say while they're at the mine site. I think that was the commission's point on looking at D. It wasn't to...
Let's suppose you had a coal mining company, and they had, they have 100 different sorts of trucks and other vehicles that are used for the coal mining, and the inspector shows up and says, I want to inspect all of your trucks. and some of the trucks are there physically at the mine, and some of them are at, basically a storage parking facility that's, 10 miles away. Can the inspector say, well, I want to inspect all the trucks, so I want to inspect the ones that are here, and I want to go to this other parking lot and inspect the ones that are there? Or can the inspector only inspect the trucks that are at the physical mine?
And you're talking about a trucking facility, Your Honor, correct? If it's a trucking facility, our position is they can inspect the trucks at the mine while they're engaged in mining services, because at that point, the commission has stated, or the Congress has stated, they're part of the mine. But when they're at the trucking facility undergoing repairs, there's no locational nexus between the trucking company and.
So I'm just trying to make the hypothetical as simple as possible. So they're not, these are trucks that aren't owned and operated by like some independent contractor like your client.
Mm-hmm.
The ABC coal mining company owns these trucks.
Mm-hmm.
But at the time that the inspector shows up at the actual physical mine, it's like, I know you all have some other trucks that aren't here. I want to see those and inspect those. And they're like, well, those are at our lot, which is 10 miles away. But we're not going to let you inspect those because they're not here at the mine. Would that be a correct way for the statute to work?
I don't think so, Your Honor, because I think that the equipment, because equipment is so fungible, that they have to be at the mine site. That's the only realistic way to do it. Even in this case, the court.
I want to make sure I understand, because maybe I got too many negatives or something in my question. Can the inspector go to the parking lot 10 miles away where ABC Coal Mining Company stores its trucks and inspect? Yes or no?
No, Your Honor, because that's no different than ABC Coal Company has bought 3 continuous miners from this manufacturing company, and they're sitting on the dock at the manufacturing company. And the inspector would say, I want to see those continuous miners. I know they haven't been delivered yet, but they're to be used in coal mining. I want to go inspect those. And that's not what Congress intended here. Congress intended for the inspector to inspect what's at the mine. So that would be my response to that, Your Honor. I understand. I know you're trying to make a close call.
Could OSHA, or the inspectors for OSHA, inspect the trucks in Judge Wilkins' hypothetical?
OSHA certainly could. Absolutely.
So what's the pragmatic reason for wanting OSHA to do it when, the mine inspector, he's inspecting the other 99 out of 100 trucks, and this one truck is 10 miles away, he's in the area already. Seems maybe more efficient to just let him do all 100.
Well, the pragmatic aspect is basically what this court recognized in National Cement when the Secretary first came with a very broad definition of their jurisdiction. And the court said, no, you can't have a vague definition that's based on prosecutorial discretion. That doesn't work. That's not doable. Go back and actually come up with something that's reasonable.
I get it, but I guess why do you care whether it's a mine inspector or an OSHA inspector?
Your Honor, I care because Congress cared, and Congress set out the statute and put these in mining and these in OSHA. And like some of my examples I gave, for example, the timbers that are going to the mine, MSHA doesn't regulate any kind of logging or sawmills or anything like that. So if you take it to this no stopping point degree, you step on OSHA regulations. These mechanics are customarily used to OSHA regulations because the other 5 KC transport facilities are inspected by OSHA, and that's where they work, and maybe they transfer over here, and maybe that's what they're trained for. So then you have, when they just happen to be at this facility, they have to undergo different regulations, different training, and it's just very confusing. Whereas the statute is a very bright line rule. If you're at the mine, jurisdiction attaches. And I think that's what the maximum court was trying to bring out. I think that's what the commission was trying to bring out.
Well, Congress wanted to protect miners and promote mine safety. And under your reading of the statute, a mining company can avoid inspection by just moving equipment off the site.
Well, I understand your point, Your Honor. I don't think that's, I don't think that would be the intention, but, the thing is if you go overly broad like the secretary has, there's just no limits. You'd have no one has any predictability. When you look at A, B, and C, that when the trucks are at these sites, extraction, milling, preparation, and roads, that they're subject to inspection. And that best protects the miners. The secretary says they don't have the resources to go out and inspect all these other places. The best way to protect the miners is to use the resources for what Congress intended, not what Congress did not intend. That's what OSHA is.
But if Congress intended for subsection C to be limited in the way that you say, why didn't they just say that? They didn't say that.
Well, Your Honor, I understand your point, and there's been people, we've argued a lot about this. It seems that if you look at it in the relation of the Coal Act to the Mining Act, and then A, B, and C like it is, and apply it the way Maxim did, where you look at the lands and the equipment, and then you kind of look back and say, well, where are these lands and the equipment? Well, they're at the extraction site, the milling site, the preparation site, on the road. Then at that point, I think they did say it. I think it is clear at that point. Like I said, in the Cal Portland, this court said it may not always be easy to read it the first time, but when you pull the lens back and you look at the three sections together, then you can understand what they're saying. And then when you throw in on top of it, the commission said under Section 3D that contractors become operators when they're at the mine site. If it's as broad as the secretary, if it's interpreted that way, then that section of the statute would have no effect, because contractors would with these type of equipment would always be operators. And that can't be what Congress intended, otherwise they wouldn't have added that other.
All right. We'll give you, we've kept you up a long time. Mr. McHugh, if you have any final arguments that you didn't get a chance to make, why don't you take a minute or so to make those?
Thank you. The last thing I would say is MSHA asserts in their brief and that it's always been this way, that this is no surprise. But even in this case, just a few years ago, there's some internal inconsistencies where there was a citation of a shipping trailer that's in the brief that was vacated. It was down next to the haul road, but the secretary chose to vacate that when Casey Transport raised a jurisdictional argument. And then in this case, the secretary's first position was, we want the trucks. We want to assert jurisdiction over the trucks. When that was determined by the ALJ and the commission to be, not appropriate, then they said, well, we want the trucks and the facilities. So, and then now before this court, they say we want the trucks and the facilities, but only want to the extent our resources. So my point is the secretary's position has never been consistent on it. Yes, we can look at some older cases and we can say, well, this is the way it was in that older case, like Jim Walter. But the court said maybe the arguments weren't made like they are. Maybe, who knows? But the commission said, no, that's not persuasive to us. We're not going to follow that. But my point is because the secretary has never been consistent on this, the court should never give them deference on it, because part of the requirement to get deference is you have to be consistent. You have to treat this trucking company like this tire company, or this trucking company like this sawmill manufacturer that's making timbers. That's the problem. If you go down, if you get too broad, then you get inconsistent. And I think that's what this court tried to point out in National Cement. Thank you.
Thank you. All right, Ms. Maltz, you were out of time, but we'll give you 3 minutes for rebuttal.
Thank you. So I'll just to address a few things that my colleague mentioned. The Secretary's position is that the statute is unambiguous. The Secretary is not asking this court for deference. The Secretary is simply asking that this court read the plain meaning of the statute, as the Secretary does. I'd like to address this sort of reasonable enforcement issue. KC Transport suggests that there will be this sort of parade of horribles. MSHA will go to Judge Walker's mother's house and cite trucks. There's been no evidence in the record that MSHA has ever done anything like that. There's been no evidence that MSHA cited trucks in diner parking lots. The statute is not limitless. There is a limiting principle in the statute. It's whether something's used in mining. And MSHA does not, go out to the fringes to terrorize diner. So that's just not what's occurred. I think we have discussed the plain meaning of the statute, and it's been thoroughly briefed, but I'll just say that the Secretary disagrees with KC Transport's reading of the statute. Subsection C does not contain a location requirement. And Congress did that deliberately. And Congress was clear that what is to be considered a mine under this act should be given the broadest possible interpretation, and close cases should be resolved in favor of mine act. I would also like to address sort of this question about whether or not maxim applies. The facts of maxim might bear on this court's decision in Carolina Stay-Lite. While that facility was adjacent to the extraction site, those weren't the grounds on which the court decided that subsection C applied. Maxim is a radical redefinition of the statute. Maxim requires a locational requirement that Congress did not, Congress didn't put into the statute. Maxim puts that into the statute on its own.
On that point, and maybe this is not fair to ask you, as opposed to you and all the people who would have gone into this decision. If Maxim was a radical redefinition of the statute, and it was going to have, as your brief says, profound importance to the safety of miners, it seems odd that you didn't seek cert. Or did you? I don't think you sought cert, but if I'm wrong about that.
No, the Secretary did not seek cert. And
doesn't it seem
may
odd?
Be odd, yes. I do think that it is fair that you find that odd.
Thanks for your candor.
Thank you.
Have any other circuits adopted Maxim, or
No.
have any other circuits adopted what we said, National Cement?
No other circuits have adopted. I think that the Fourth Circuit has Harmon in the Fourth Circuit sort of. I apologize that I don't have the facts of Harmon at hand, but other circuits have sort of considered MSHA's jurisdiction, and only the Sixth has required this locational element. I'd also like to address, just very briefly, Section 3D and the Commission's sudden announcement in its decision that independent contractors are only citable as operators under the Act if they are physically present at the mine. The Commission did not have jurisdiction to raise that issue. That issue appeared for the first time in the Commission's decision. There are two avenues for the Commission to exercise, there are two avenues for the Commission to reach an issue. It can be raised by the parties, or the Commission can direct review of that issue on its own, but directing review of that issue on its own requires the Commission to hold a vote. Oh, I apologize, I see I'm over time. I'll just very quickly conclude. It requires the commission to hold a vote, and it requires the commission to issue an order announcing the issue that it plans to reach. And the commission didn't do that here. The commission did not have jurisdiction to reach the 3D, section 3D question.
I have a question. So I mentioned before that the legislative history that was cited by the parties, the Senate report, talked about how this new definition of coal or other mine was incorporating the definition from the Federal Metal and Non-Metallic Mine Safety Act. And I just pulled that act up in the definition of mine from that act. And in the subsection 3 definition from that definition of mine does appear to be verbatim taken into the new statute that we have here, the Mine Act from 1977, except that it left out some language with respect to radioactive materials. And I don't know if it mentions that in the Senate report that was cited, but there was a House conference report that I don't think that the parties cited for the Mine Act of 77, but it talked about the fact that this radioactive materials wasn't going to be included in the definition of mine for the Mine Act of 77. All of this is a long way of saying that wouldn't it be relevant to see how, if at all, courts and or the secretary interpreted this identical language from this prior act to see what the construction should be when it has been kind of engrafted into the Mine Act?
Yes, it could be relevant. I apologize for not being familiar with the language of that act, but I think what's more relevant here is how, is the plain meaning of the statute of the Mine Act and how this court has applied that plain meaning.
I mean, I don't know that it's the case, but what if the court had construed this prior act and said that we think that the plain meaning is X? That would be something that we would want to know.
That could be very relevant, yeah.
Any other questions? All right, thank you. We'll take the matter under advisement.
Thank you very much.
Case number 22-5104 et al. Ascendium Education Solutions, Inc. versus Miguel A. Cardona in his official capacity as Secretary of the Department of Education and Department of Education appellants. Mr. Hazel for the appellants, Mr. St. John for the appellate.
Good morning, Mr. Hazel. We will hear from you.
Good morning. May it please the court, Stephen Hazel for the government. If I may, I'd like to reserve 3 minutes for the Higher Education Act provides borrowers who create no meaningful costs, prevents borrowers who create no meaningful costs from receiving collection charges that amount to thousands of dollars. When a borrower refuses to cooperate and thus requires coercive and costly activities, collection charges are authorized. But when a borrower cooperates quickly, there's no need for those activities and no basis for a collection charge. The agency has interpreted the statute this way for decades. The Seventh Circuit has approved that interpretation, and the same result is warranted here. The basic flaw in Ascendium's argument is that it assumes that all costs associated with defaulting borrowers are collection costs. That's not consistent with the statute's text, its structure, and with its funding mechanism.
Can I ask you a question about that? Because it seems to me that you have framed your arguments based on this distinction between collection costs and administrative costs. Isn't it easier and more, I guess, intuitive to look at this as permissible under the Secretary's prerogative to define reasonable collection costs and hold that the section about the 16% cap needs to be read in conjunction with the section that talks about reasonable collection costs. And therefore, I guess it's section 20 USC section 1078-6. It says the guarantee agency may, in order to defray collection costs, charge the borrower an amount not to exceed 16% of the outstanding principal and interest at the time of the loan sale. Why can't we just read that as something that needs to be reasonable? That just seems to be the more logical way to look at the way the Secretary exercised his discretion in this case, because the Secretary is still also bound by 20 USC section 1091A, which says a borrower who has defaulted on a loan made under the subchapter shall be required to pay, in addition to other charges specified in this subchapter, reasonable collection costs. These are not in conflict with each other because a borrower in a rehabilitation plan is also a defaulted borrower. So the collection costs on them also need to be reasonable. So it seems to me that looking at it this way seems to be a stronger argument for you than trying to distinguish between collection costs and administrative costs, because that requires you to argue that there are no collection costs in the first 60 days, and that's not clear.
Your Honor, let me take that question in two parts.
Yeah.
So first, on the relationship between those two provisions, I think it's absolutely right that those are closely related. That reasonable collection cost provision says that when there are those costs, the guarantor can collect them, including against borrowers who enter rehabilitation agreements. The second provision, that rehabilitation cap provision, says when those costs are assessed, they can't go above the 6% cap. And we know that because, or among other reasons, there is that in order to defray collection costs language. So Congress is very clearly linking these two provisions. So I think that's absolutely right. On your broader point, Your Honor, about sort of how to use the word reasonable here, the agency's interpretation going back 3 decades now has been that there just are no collection costs in this period, and I'm happy to say more about why that's the.
No, I understand that, but my question is, why do you need to rely on that when you can just rely on the fact that even under Section 1078-6, those have to be reasonable, and you can interpret that to be it's not reasonable to collect them in the first 60 days.
Your Honor, again, the agency's interpretation is that there are just no collection costs. Certainly, at a minimum, because the word reasonable is in the statute, as you point out, this would be an entirely reasonable approach that the agency has taken, and as the Seventh Circuit has approved. So we don't have any objection to that reading. Just that we think that there is also this interpretation of collection costs that is independently supporting the agency's interpretation.
My understanding is you've raised both arguments.
That's right.
But your emphasis is on the collection costs one.
That's correct.
And I guess I was just wondering why.
Your Honor, it's partly because of the history of this regulatory approach and the way that the agency has explained it before. But you're absolutely right that we have raised raise both, and of course we would welcome a decision from this court on either basis.
So just to be clear, if we disagree, just hypothetically speaking, if we disagreed with you and believed that there were some collection costs, that we thought that the secretary was wrong to say that there are no collection costs, I think that there are some. Your fallback argument is consistent with Judge Pan's questioning, which is that, well, the secretary could still define reasonable collections costs to exclude whatever those costs are.
That's right, Your Honor, and I would say that this aspect of our argument ties into the Seventh Circuit's approach. Their emphasis was, look, what Congress was really focused on here were these costly activities, things like civil litigation, things like wage garnishment. By comparison, the activities that are performed in connection with these borrowers quickly, things like sending a form letter, that's a tiny cost. It's negligible in comparison. That's not the kind of thing that Congress would have been focused on. And at a minimum, it was reasonable for the agency to decide that wasn't the sort of thing that Congress was focused on. I do want to address, though, the collection costs piece of this, because it is true that there are no costs related to these.
Before you get there, let's stay in this world where we don't agree with you on your main argument, but we're inclined to agree with you on your fallback argument. What would you say to counter that 1078-6's reference to 16% is supposed to inform what a reasonable collection cost is in the rehabilitation context? In other words, 1091A speaks in general terms about reasonable collection costs. 1078-6 speaks in specific terms about what a reasonable collection cost is in the rehabilitation.
Your Honor, 1078-6, and I realize there's a lot of different provisions flying around here, but that 16% cap, I think the fact that Congress put in a cap for all rehabilitating borrowers, so that includes borrowers who do not cooperate quickly, who it might take many months or many years of collection activities before they finally enter a rehabilitation agreement. I think the fact that Congress wanted to cap even the amount for those borrowers, that's entirely consistent with the Secretary's approach here in saying that for the people who cooperate quickly, who do all the right things, like the Bible plaintiff who enter these agreements quickly, those people shouldn't be charged any costs.
So, go ahead.
I was just going to say I do want to get to the
whether there are. I think we'll let you. But just like Judge Wilkins, his cards on the table. Last argument, I'll put mine on the table here. I'm inclined to go with you on what you just said. I think that your argument would be stronger if 1078-6 said guarantee agency shall not charge more than 16%. Instead, it speaks in affirmative terms. It says the guarantee agency may charge up to 16%. That seems a little bit harder for you. You agree?
Sure. I guess I'd point to two other features of the text of that provision. One is, of course, in order to defray collection costs language, which I think is helpful for the reasons we've already discussed. It also pointed to the may not exceed language. I think what Congress wanted to do was to set a cap, may not exceed. Those are exactly the words Congress would use. If what Congress was trying to do was to create this standalone entitlement to a fee, a rehabilitation fee that's entirely untethered from collection costs, which is what Ascendium's argument is, there's no way they would use that kind of language there.
I can't speak for my colleagues, but I'm fine with you moving to the argument and trying.
Thank you.
And that I did not let you.
I appreciate that, Your Honor. So on this collection costs point, I think two features of the statute are particularly helpful here. One, as we pointed out, is this distinction that happens again and again throughout the statute between administrative costs and collection costs. One example is 1080B, and just a quote that refers to the costs of recovery, including administrative costs and collection costs. Congress couldn't have written that if it didn't think of these as two different categories, both of which are costs of recovery they have to mean two different things. Ascendium hasn't even attempted to provide a definition that would give meaning to both of those terms. And of course, the Secretary has. And I think in thinking about that distinction and giving it meaning, what's helpful is also to think about the structure of the statute. So in this default phase, the unique feature of that phase is that there are these coercive activities like civil litigation. That doesn't happen anywhere else. It doesn't happen in the lender phase. And so given that context, when Congress used the word collection costs, when it enabled these charges, that would have been a natural shorthand for thinking about the costs that are unique to this default phase, which are these coercive activities. And I think that understanding of the statute is reinforced by common sense. So if we think about what happens with the borrowers who are covered by this rule, they receive a form letter, they enter a standard form agreement, and that's it. Those are all the costs that are associated with them. Most people would say those sound like administrative costs, not collection costs. And Congress at least reinforced that in Section 1082L, which is talking about these routine communications between borrowers and guarantors, and it refers to those costs as administrative. So it's common sense, and it's the way that Congress thought about this part of the statute.
You point out in your brief that Ascendium is in this case in a way that similarly situated organizations have chosen not to, and that in fact those similarly situated organizations may not even have opposed the rule that's being challenged. And I see how that helps you a little bit atmospherically. I wonder though, it's not unusual for regulated parties to seek regulation because they know it will hurt their competitors more than it will hurt them. Is that what's going on here?
Your Honor, I don't know what's going on with this industry. Ascendium may know more. I mean, I think what we were getting at that point is that this is an average cost system. So these are not costs that are tracked on an individual level. There are these, you either get these charges or you don't, and they're usually a couple $1,000s. And so what Ascendium is asking for here, what its interpretation would do, is that these people who produced no collection costs in the agency's view and tiny costs regardless of how you categorize them would have these huge charges. And that certainly wasn't the Seventh Circuit's idea of what the statute did. There's nothing in here that suggests that Congress meant to compel that sort of result.
And I would concede it may not be a fair question, but it is fair because you started it with what you said in your brief.
Fair enough, Your Honor. On this average cost point, just for 1 minute more, I do want to point out, Ascendium benefits from this. Other guarantors benefit from it. They certainly haven't challenged it. So this is just sort of part of the regulatory backdrop, I think, against this case needs to be decided.
All right. Any other questions? Yeah. We'll you can either wrap up or we'll give you some time on rebuttal.
Okay. Thank you, Your Honor. I'll be back.
Thank you. Mr. St. John. Morning.
Good morning. Thank you, Your Honor. And may it please the court. Congress spoke precisely to who guarantors may charge the rehabilitation fee. Every borrower who the guarantor assisted in rehabilitating defaulted student loan. And Congress also spoke precisely to who must pay reasonable collection costs. Every borrower who defaults on the student loan. The department's challenge rule says that some of these borrowers who Congress required to pay these fees do not have to pay these fees. And our position is that the department lacks the statutory authority to substitute its judgment for that of Congress. Now, the department has defended this rule as we're just defining reasonable collection costs. But that's not what the challenge rule does. The challenge rule doesn't contain a definition of reasonable collection costs. It doesn't alter the definition of reasonable costs that exists in the regulations. It doesn't change what activities are part of collection costs. It only creates an exception. The plain text provides that a guarantor may charge collection costs, may charge the reasonable cost of collection on a defaulted loan unless the borrower undertakes certain activities, in which case the guarantor may not charge any collection costs. This is an exception, not a definition. And Congress already occupied the field as to who should pay these costs. Second, the definition of reasonable collection costs cannot affect the application of the rehabilitation fee because the rehabilitation fee statute does not use the term reasonable collection costs. Congress determines directly that an appropriate and reasonable fee would be up to 16% of the principal and interest of the loan at the time it was sold.
May I ask you about that, though? Why do the collection costs referenced in 1078-6 not have to be reasonable when it can be harmonized with 1091A, which says they need to be reasonable? They're not in conflict. Why don't we read them together and require the costs in 1078-6 to be reasonable?
Well, for a couple of reasons. One is that these fees they're different fees. And so 1098 says that, 1098 provides that the default borrower must pay reasonable collection costs in addition to other charges that are specified in the statute. The rehabilitation fee statute says that the guarantor may charge this particular fee.
To defray collection costs. So they're both about collection costs. To defray collection costs.
That the purpose of the fee is to defray collection costs. But I want to emphasize they can't be the same fee. And part of the reason why that's the case is that the proceeds of those fees, the fees go to different places. So when a guarantor collects a standard default collection fee, the vast majority of that fee, those collections, is returned to the Department of Education. And that in the case of a rehabilitation fee, Congress set up a different system. And the recovery of rehabilitation is retained by the guarantor. But 100% of the proceeds from rehabilitation, 100% of the collections on the rehabilitated loan are given to the department. The second point
I'm sorry, can you just clarify, why does that change the nature of the fees as collection costs?
Well, therefore,
just because they're going to different places doesn't mean they're not both collection costs covered by both statutes.
I'm just trying to make the point that there are different fees, and the HEA, even in the standard default collection fee statute, recognizes there can be different charges. But the second point I want to emphasize is that there are different collection activities that lead to the assessment of those charges. Whenever a guarantor enters a rehabilitation agreement with a borrower, it is engaged in unique and different collection activities. Congress called the rehabilitation program a repayment incentive. The purpose of rehabilitation is for the guarantor to collect amounts due and owing on a defaulted loan. The guarantor doesn't engage in those collection activities unless there is a rehabilitation. And so Congress recognized that there's going to be, we agree that the language in order to defray collection costs is Congress's recognition that there is collection activity. But it's different collection activity than that is contemplated when there are other types of agreements in place. And Congress set up the system where the guarantor doesn't get paid collection costs for any or the rehabilitation fee unless it successfully completes rehabilitation with the borrower. And that means you don't assign the costs as you go along on a month-by-month basis. You assign the fee when you were successful. That means going out, soliciting a buyer of this loan, finding the buyer for the loan, getting the proceeds of that loan, which would be paid to the U.S. government so that its liability that it incurred when there was a default is paid hopefully fully.
No, I understand that there are differences between repayment plans and rehabilitation plans. I just don't understand why that distinction makes a difference when you're defining collection costs and interpreting these two statutes, which refer to collection costs. We're still talking about collection costs in both contexts. The statute still says they need to be reasonable. There's a cap imposed by 1078-6, but I don't see why the differences between the two lead to the conclusion that you are urging, especially since the rule says that a repayment agreement includes a rehabilitation agreement. Why can't the secretary define it that way if they wish to?
I think there are many problems with defining it that way. First of which is that Congress already made the determination that there would be a different fee for completing a rehabilitated loan, which is a special program. And in Congress, rather than saying it'll be reasonable collection cost here, actually picked a number. And Congress conferred upon the guarantor the direct authority to assess that fee. There's no delegation to the secretary.
But that's your interpretation. I don't see why it's not reasonable to interpret this the way the secretary did, which is that they're all collection costs. This is a cap on the collection costs that can be obtained, and they have to be reasonable.
Sure. Well, let me try a different approach here, which is that Congress said that when there is a loan rehabilitation, there would be a rehabilitation fee, or the guarantor has the authority to charge that.
May charge that. To defray collection costs.
Right, may charge it. To which borrowers? To those whose loans are successfully rehabilitated. When will it be charged? On the successful completion of rehabilitation. What will the amount be? Up to 16%. But what I want to emphasize is, again, the work that the guarantors do with rehabilitation is unique, that relates to rehabilitation, and doesn't occur in other contexts. It is totally reasonable for the department or for Congress to make the decision that there should be a fee for helping this borrower out of default and for recovering likely 100% of the money that the U.S. taxpayers have paid on this loan. So my position is Congress made that determination.
No, I very much understand your position, and I don't want to belabor this. So I'll just ask you this one final thing. But why can't the secretary interpret that provision to require that the collection costs have to be reasonable, and that it's not reasonable to assess them in the first 60 days because they're not. It doesn't cost them that much to do this.
Well, so I have a couple of different responses to that. One is the challenge rule permits the guarantor to charge 16% if the rehabilitation agreement is entered on day 61. The guarantor has engaged in no different collection activity between day 60 and day 61. The guarantor doesn't need to engage in coercive collection activity for many, many, many months. The department's challenge rule isn't defining reasonable collection costs here when the guarantor's activity doesn't change. The department is trying to encourage borrowers to enter into these agreements, but Congress determined what were the rules and conditions for these agreements and what fee that they would be charged. So I think that, Your Honor, that the question is more hypothetical. Could the department use reasonable collection costs to limit the fee? Now, our position is still no. Our legal position is still no. But our observation of this challenge rule is that that is not what this challenge rule does in any way. Instead, it prohibits them. And I would take a step back and say, well, what are the conditions? Take a step back and say, what are the conditions under the department's logic that this fee that Congress acknowledged could be charged would ever be provided? Is it only in the circumstances where the guarantor is under a wage garnishment? But Congress didn't say that the rehabilitation program was only open to those who were involved in wage garnishment. Congress made that program available to every defaulted borrower, and Congress recognized the ability to fee to every defaulted borrower. And again, I want to emphasize, the guarantor is going to do the same work no matter when a rehabilitation fee is borrowed. And it's not that we've done X amount of collection work before 60 days. It's also that entering rehabilitation, what goes on between the borrower and the guarantor during the next 10 months is also collection activity. It's a repayment of a defaulted loan. Congress called every payment received an amount collected on behalf of the defaulted borrower. It's a special program that only the guarantor can operate, and the guarantor only holds the loan after default. And this brings me to, I think, the next important point of this case, which is Congress determined that default was going to be the trigger to pay collection costs. Now, Congress didn't say you've got to pay collection costs if you miss a payment or 2 or 3 or 4. Congress statutorily defined default to mean 270 days. The challenge rule effectively says, no, 270 days plus 60 days, at least 60 days, if certain things happen. That is, I think, a clear conflict with the statute. And Congress didn't just define 270 days out of a hat. It used default for a purpose. Now, the borrower that gets to this point is contacted multiple times before default to be offered repayment plans. Here's how you can avoid default, and told about what the consequences are of default. But the consequences of default are more than just what happens to the borrower. It's on default that there are significant consequences to guarantors and the American taxpayer. It's on default where the guarantor pays the lender's claim, where the U.S. taxpayer, through the Department of Education, pays the guarantor's reinsurance claim. The guarantors are out a bit, the U.S. taxpayer is out a lot, and Congress determined that the guarantor then has to exercise due diligence to collect on those loans. And it begins to collect on those loans right away. Now, the Seventh Circuit in Black recognized that standard default collection fees enacted because of the losses to the public fisc. Congress made a determination not only that borrowers should pay for some of the costs of their default, but also the department recognizes in its rule that these collection charges have incentive effects, right? And in those incentive effects, Congress is saying, if you default, you'll have to pay collection charges. The hope is this will reduce the number of defaults.
That argument would seem to also help. That argument would also seem to help the government's position here, because there's an incentive effect from the rule that they've chosen. They've incentivized the borrower to get right within 60 days after default. Doesn't that speak to the reasonableness of the rule?
Well, with all due respect, in terms of the incentive effects, Congress is the one that chooses the policy. And they did choose this policy about when collection charges would be applied. And they did choose default. And what's important about the department's policy, though it may be a reasonable one in the abstract, is that it not only conflicts with the plain language of the HEA, but that it also undermines the congressional policy. Because if a borrower does not have to pay collection costs upon default, then whatever incentive effect is created by collection charges isn't going to be felt before default. And yet what Congress is most concerned about is no defaults, because no defaults means no payment from the U.S. Treasury to guarantors, and from the guarantor's perspective, no payment from the guarantors to the lenders. So I believe that we have to look to what Congress said in Congress's policy, and Congress's policy has to trump the department's policy.
So Congress allowed the secretary to interpret reasonable collection.
But Congress did not permit the secretary to change the subclass of borrowers who were required to pay reasonable collection costs.
That's what this case is about.
Which is what we believe this case is about, because that's the language of the statute which is trumped. That's the language of the statute which the department's challenge rule undermines by creating this section. And I do want to emphasize that guarantors do engage in collection activity every time a loan is in default. And that activity begins right away. I see that my time is up, Your Honor.
I have a couple of questions. Just clarify something for me. How do guarantors make money in this business?
How do guarantors make money in this business? Well, guarantors have several responsibilities. Some of those responsibilities, which are pre-default, there are payments that are made to the guarantors. For example, there's an administrative maintenance fee payment which is made to guarantors that relates to the size of their current repayment status portfolio. The percentage is based on how big your portfolio is. Second, Guarantors are paid if they
And
successfully.
that fee is paid by who?
That fee is paid by the Department of Education, by the Secretary. Second, there is a fee that Secretary provides if the guarantor successfully helps a borrower avoid default. It's called the default aversion fee, but the basic program is the lenders call for help at some point during delinquency. If the guarantors provide that help and the borrower avoids default, then the guarantors receive a fee. Collection costs are another avenue which we've talked about here today. Initially, there were also loan origination, fees. When there was a new loan originated, the guarantor would be paid a percentage. However, this program has not had new loans initiated in it for a long time. It's a legacy program.
So, I guess the reason I asked that question is I guess the way I look at the statute is that by saying reasonable costs, the statute could be construed as like sometimes you kind of do rough justice, or you kind of have to eat some costs. May not be able to recoup every penny. And then sometimes there might be someone who is kind of like a free rider, so to speak. If I invite 10 people to lunch and say I'm going to ask all of you I'm going to pay for everything and order everything and have all the food there, and I'll just ask you all to, reasonably reimburse me. And let's say an 11th person shows up and they say, I've got my bag lunch, but they ate one of the cookies that I had bought for the other 10 people. The other 10 people, be reasonable for them to just kind of subsidize the cost of that cookie and not charge the freeloader for the cost of the cookie. So, these things happen where it's in. I guess what I'm saying is it doesn't seem to be the case, and it doesn't seem to be your argument that because of this construct, I guess your client is losing some money to the extent that they can't recoup what it believes are some costs under this. But kind of in the scheme of things, your client is recouping money when people avoid default, and you help them do that successfully, and that sort of thing. I'm just trying to figure out why this is, to the extent that there's some unfairness here, why is there some sort of manifest unfairness?
And I'd have to again return to the statute, because there might be many ways to define reasonableness, but you can't pick a way to define reasonableness that changes the classes in the statute. And so in the lunch example, for example, if Congress had said everybody who attends lunch must pay a $20 fee, to play with the hypothetical, then there would be a problem if there was a person that was there that didn't have to pay the fee, because Congress determined that is ultimately would be appropriate. And again, I want to emphasize that nothing about this rule defines reasonable collection costs. This is a red herring argument by the government, because the guarantor's collection activity with respect to a rehabilitated loan, rehab-related collection activity, does not depend on when the rehabilitation agreement is entered. It's the same in every case.
But can I ask that? So if somebody enters a rehabilitation agreement much later, there's not costs accruing as you're trying to persuade them to do something?
There are costs that are accruing that relate to reasonable collection costs and the standard default. But the work with respect to rehabilitation, which is the work that Congress identified,
but the collection costs for that borrower are going up Because if they enter their rehabilitation loan later, in the interim time before they enter it, costs are accruing.
That is correct.
And those are collection costs.
Right, and the rehabilitation fee is for completing rehabilitation. And so those services don't change from one case to another. I don't want to repeat unnecessarily the argument.
No, I think I
that's our
understand your
position.
argument. I'm just not sure I agree.
Sure. I mean, this is Judge Wilkins' hypothetical, I think. I think it cuts against you. You tell me why it's wrong. Congress says to someone, you can organize a lunch. You can charge people who attend the lunch a reasonable fee. You can't charge anyone more than $20. Now, the 11th person comes along, and the organizer of the lunch says, I know I can't charge you more than $20. I actually think it's reasonable to charge you a lot less than I've charged everyone else because you brought your own lunch. You only ate a cookie. Isn't that the case?
Well, I think that with respect to the rehabilitation fee and the rehabilitation statute, Congress said to the guarantor or to the person hosting the lunch that you may charge $20 for the attendance of the lunch. It didn't say you had to, it said you may. You may charge up to $20, an amount not to exceed. The guarantor, in the guarantor's discretion, can choose, I'm not going to charge $20 to the person that brought their own lunch. But that hypothetical, there's no delegation to the department or another entity to come in and say, although Congress told you that you may do this, we're telling you that you may not do this. And that ultimately is what the challenge rule does. Congress didn't leave a gap here for the department to enter into the equation. Also, one thing about that hypothetical that couldn't be a perfect analogy to the rehabilitation context is in each and every case, the work the guarantor is doing at the lunch or in hosting the event is the same. So there isn't a borrower that comes into rehabilitation in a significantly different space with respect to the event that's being hosted. The guarantor is still going to have to go out, collect the funds from the rehabilitation, find a buyer for the loan, sell the loan, put the proceeds to the government.
Right, thank you. We have your argument.
Thank you, Your Honor.
So, Mr. Hazel, I think you had maybe, not sure how much was left on the clock, but why don't we give you 3 minutes?
Thank you, Your Honor. Just 3 quick points. One, on the rehabilitation fee argument, Congress recognized and made clear that borrowers who enter those agreements, the rehabilitation fees are supposed to be reasonable and affordable, often $5 a month. Ascendium's argument would mean that at the end of that period, they would get a several $1,000 additional charge. That just can't be what Congress intended. And that's why every court, every judge, including even the Bible dissent that Ascendium is otherwise relying on, none of them accepted this reading of the rehabilitation fee. Second, on the rule, counsel said that we're making a red herring argument here. No, this rule makes clear that borrowers who cooperate within 60 days cannot be charged collection costs. The explanation for the rule explains that's both for the reasons that the Seventh Circuit gave and because of the department's longstanding position that there are no collection costs in that period. That's something that has been in the regulation since 1992. It's been reaffirmed and reiterated in our briefs, the Bible Black litigation in a 2015 Dear Court letter. So this is by no means a new argument. And then finally, Judge Wilkins, you asked about funding for guarantors during this period. A guarantor who is working with a borrower who cooperates quickly has 2 sources of funding aside from collection charges. One is the department earmarks funds for administrative expenses. That's 1087H, and those are paid including for the loans related to rehabilitated borrowers. And the second source of funds is that each time those borrowers make a real rehabilitation payment, the guarantor gets to keep money from that. So there are, this is not a situation where Ascendium is not making money from those borrowers. They have both of those sources. If I'd be happy to answer any.
I have one clarification question. Ascendium said that the reasonable collection cost is separate fee. They do not keep themselves, but rather send to the department. And they contrasted that with the rehabilitation fee, which comes at the end, which they do get to keep. Is that all actually correct?
So, Your Honors, my understanding is that for the rehabilitation payments, Ascendium does get to keep those, and that would be 1078,682.
And they don't keep the reasonable collection.
So they do keep the reasonable.
He said they send it to the department. Was he, your opposing counsel, your friend on the other side said that the reasonable collection cost is a separate fee that Ascendium ultimately sends to the Department of Education.
I don't think that's correct, Your Honor. For the group of borrowers that we're talking about, those who enter rehabilitation agreements, the particular provision is 1078.6, and that says when those rehabilitated loans are either assigned to the department or they're sold to lenders, either way, the guarantor is getting to keep a sum.
Okay, it's helpful. I'll check it out. Thanks.
Great, thank you. We'll take the matter under advisement.